All right, good evening. We're live. This is Meet the CPS Experts. I'm attorney Vince Davis, and my guest tonight is, I believe she's logging in right now. Her name is attorney Jennifer Ani. She's going to be with us, and she is an expert in representing people in juvenile dependency and CPS courts. So what I'd like the audience to do, if you have questions, whatever social media platform you're watching us on or whatever page you're watching us on, go ahead and post questions, and we'll try to answer them for you. Either I or Jennifer will try to answer them for you. Oh, there's Aaron Carranza. Good evening, Aaron. And we have Yolanda Hill. Yolanda, hello, just stopping by to say hello. Hello. And thank you for checking us out tonight. And one of my favorites, Denise Chavez. Hi, Denise. How are you? Hope the family and your husband are doing well. I'm wondering what is happening to Jennifer if she's logging in. While we're waiting for her, does anybody have any questions they want to post? They want me to answer this evening. Okay, here's a question from Aaron Carranza. Aaron says, "Why is it a bad idea to do a GoFundMe to pay for an attorney?" I don't necessarily think it's a bad idea. The problem is you, from what I've seen, you don't get a lot of traction. It's probably not something that where you're going to raise a lot of money. Other than that, you can try it. I I don't think there's anything illegal about it. Um, but you can always post and always try to see if there is going to be traction. Sometimes when you're hiring a private attorney, it could, range in the thousands of dollars. And I generally don't see people spending that type of money on GoFundMe. Um, Aaron says, I thought it was frowned upon. I'm not sure it's frowned upon anything, but I did have someone tell me not too long ago, a client tell me that, she was a potential client, that the judge in her case ordered that she could not set up a GoFundMe account to raise money, which I thought was kind of unusual. But I don't think there's anything illegal about it, especially if you're not mentioning any names, of your children. Um, so I don't think there's anything um, wrong with it. It's just the way, getting, I guess, people to actually give money. All right, here's Denise. How can we come about getting the investigative report from the social worker? Well, you can just ask your attorney, or you can just ask the social worker to give it to you, or you can just go to the court clerk and ask for a copy of your entire file. So hold on a second. My guest was telling me she had some difficulties. All right, let's go to another question. Oh, there she is. She's here. Jennifer, you're here.
Hi.
Good evening. How
Good
are
evening.
you?
How are you?
I'm doing fine. How was your day today?
It was very good. Relaxing.
Relax. All the courts were closed today, huh?
They were.
Okay. Listen, our audience probably doesn't know you. And you were at one time based in Northern California.
Correct.
And now you're doing cases all over California with me and my law firm.
Yes.
Why don't you give us a little bio about yourself, who you are and what you do?
Well, I have been an attorney since 1993. I've practiced in juvenile dependency exclusively. I am a child welfare law specialist as conferred by the National Association of Counsel for Children. And my passion really is helping families.
So how long have you been doing juvenile dependency / CPS work?
About 23 years.
And you started where, in Sonoma County or another county?
Sonoma County, Marin County, Northern Bay Area. And I worked for the Family and Children's Law Center in Marin County for the AOC. And then I went on my own and I started representing only parents and grandparents and basically doing CPS defense work.
Okay, tell us what is the AOC?
The Associated Office of the Courts. It's the body that pays for the court-appointed attorneys. I was a minors counsel when I first began in Marin County.
Oh, you were a minors counsel.
Yes.
How many years did you represent children?
2.
2 years, and then since then you've been representing parents and relatives.
Right, except for a year and a half in 2019, I also represented children in Las Vegas, Nevada.
Okay, are you licensed in Las Vegas?
No, I'm not.
Okay.
But I was able to appear. There's a special statute that allows attorneys from other jurisdictions to participate in Las Vegas as counsel when you work for a public entity like that.
I see. Okay. Now, last week on this show, Meet the CPS Experts, I had attorney Art Lasalento on as the guest.
Mm-hmm.
Do you know Art?
Yes, of course I do.
Okay. And I asked Art an interesting question. And after the show, like the next day, he and I, we were talking. And he said that a question I asked him caught him off guard. But I'm going to ask you the same question. What is the most, I guess, outrageous case you've ever been involved with? What did it entail? I don't want you to mention any names, of course, but tell us something about the most outrageous case you've ever seen.
Well, animal, vegetable, or mineral. I mean, we have several categories of alleged abuses in CPS. Probably a sexual abuse case that was started out as a family law case. And one parent made allegations of sexual abuse against the other. And it went on for 6 years while CPS did an investigation. I mean, I'm not sure what you investigate for 6 years. And at the end, the result was probably the parent, even if they did do sexual abuse, it was 6 years ago, so nothing has happened since. So it's probably okay, go back to sharing custody. I find that outrageous.
6 years? A
6
case was
years.
open for 6 years?
6 years.
Is that statutorily possible?
No, but again, as I said, it started out in family court.
Oh, I see. Okay.
Right.
I don't think I've ever told this story on any interview or show that I've been on, but many years ago, when I was a court-appointed attorney, we're talking about maybe 25 years ago, I was appointed to represent a gentleman who allegedly was a Mexican mafia member. And he had been accused of sexually abusing his 4 or 5-year-old daughter. And he swore, and at the time he was in custody, and he swore to me up and down that, he didn't do it. But, the girl was allegedly willing to testify. When the case finally went to trial, I thought, well, I have nothing to lose. So I'm just going to go all out and, cross-examine this young lady. Now, these days, they try to protect children from testifying in, these types of trials sometimes. I don't know if you ever get it, but I get it all the time. I want to call the minor as, the alleged victim or the alleged witness as a witness in the trial and to cross-examine that person. And they, are hesitant. And they make motions to keep the child off the stand for many different reasons. Well, back then, there was no such rule. And most of the judges were like, well, if somebody's making an accusation, there's that constitutional right to cross-examine. Anyway, so I cross-examined this young lady. And during the cross-examination, she says to me, well, that's what my grandmother said. And so I explored that deeper and deeper. And this was the maternal grandmother. He, of course, is the father. And of course, they blamed him for the demise of their daughter who was on drugs and, basically, but they weren't going to let this happen to the granddaughter. and let him raise the granddaughter. Well, during the cross-examination, I asked a question. And this is, I felt it was like one of those things like, do I go for this or do I not go for it? And I asked the girl, I said, well, and I'm pointing at the judge, and we're in chambers, by the way, he touched you too. Isn't that true? And she looked at him and she said, yeah, he touched me. And then there was another male attorney in the room. And I pointed to him and I said, he touched you too, didn't he? And she said, yes, he did. And at this point, the judge says to me, stop, we're going to excuse this witness. And I think that I'm going to get, basically reamed for doing what I did, because it was kind of a stunt, really, if you think about it. But after we continued, the girl confessed that her grandmother told her to say all these things so that she could continue living with the grandmother. And if I recall correctly, the grandmother was employed by law enforcement. And as the story came out, this was a way to get rid of my client, to put him in jail where he, quote, belonged as a gang member, to get him away from the mother and to get custody of the grandchild. What a perfect plan. Except they didn't know the case was going to be put to trial. And to be honest with you, I'm going to be honest, I didn't think we were going to win that trial. As a matter of fact, they had offered me so many deals that I advised my client. I said, you should take this deal. And he's like, nope, I'm not taking any deal, Davis. I didn't do it. And I don't think anybody ever suspected that we would put the child on the stand. And to be honest with you, I did it because I didn't have anything else. And it was a sex abuse case. And of course, the case was dismissed. He's in jail, though, for the same crime. So it takes about a month, maybe 6 weeks, for the DA to start processing the fact that they're going to have to dismiss this case on this alleged gang member, which they didn't want to do. They just wanted to put him away. They didn't care what it was for, right? They just wanted to put him away. And anyway, he was dismissed and he gets out. He gets the child in his custody. And wouldn't you know, 3 or 4 weeks later, he gets arrested for something else completely unrelated. And he's back in jail. And I don't recall what happened to the child because the court was hesitant on placing the child with the grandmother who had put the child allegedly up to this story. So that's my famous sex abuse case. But nowadays, if I had that case and I called the child as a witness, they probably wouldn't let me call her. What do you think?
No, I don't think that they would. And I'm running into that problem in a couple cases that I have right now. I'm going to have to put the child on because the allegations are coming from the child. And I'm not sure how the court's going to react. I know that a few judges in Monterey Park will allow it in chambers. I've done that a few times, but this is a San Bernardino case. I'm not quite sure how I'm going to get around that because and I don't think it's constitutional in any way, but the going trend is to just deny a request to interview the child or to put her on the stand, him or her.
What do you think about that? The alleged victim you can't call as a witness because they claim that the burden of having that child testify is worth more than protecting the rights of the parent. What do you think of that?
Well, I think that is a wrong approach, and for the following reasons. First of all, it's not just the parents' rights. The parents have a right to have the child in their care and raise the child, but the child has a corollary right to be raised by the parents. So the family has a right to be together, and they shouldn't be separated without a really good reason. Those reasons need to be developed because exactly as your hypothetical or your case just said, there are times when children are coached. And that's got to be one of the most despicable things, I think, is coaching a child in a case like this. I don't know how those people sleep at night. you know, using this system for that type of a gain. And I think it happens quite a bit. It's depressing for sure.
I think people do it, and because it's, the ends justify the means. And I'm not sure that our system is set up to really evaluate those types of issues because, I've talked to a lot of people in my career, like, I didn't do it, Mr. Davis. But a lot of times, I talk to people and I really get the feeling, hey, you're telling me the truth. Not that it's my job to determine who's telling the truth and not telling the truth, but sometimes people tell me things and, I'm flabbergasted. I'm not sure what we can do or what we should do.
Right. I agree. The burden of proof in these cases is different than it is in a criminal case. And so many people don't understand that from the start. And, should it be beyond a reasonable doubt in these cases? The assumption is that err on the side of caution and the state's interest in protecting the child, outweighs having that significant of a burden. But I'd rather be in jail than have my child removed. So, I don't know. I think that parents should have more, rather stronger rights. They really don't have any rights at the trial level in dependency.
Mm-hmm. Do you think that having a jury trial would make any difference in these, say, jurisdictional and dispositional hearings?
100%. Absolutely.
There are a few states that give you the right to have a jury trial if you want. But I'm told by a lot of lawyers that work in these different states, these few states, that it's rare that a jury trial even proceeds. Mainly because if the state or the county believes they're going to have a jury trial, cases are resolved fast and, a lot easier. And
Sure.
if they don't, a lot of people are concerned that how is a jury going to react to an alleged, quote unquote, child abuser? Maybe you don't
Well,
want to have the jury do it. Maybe you do want to have a judge.
and maybe you don't. As we know, these cases are individual and case by case, but I sure think it would be helpful, especially in cases of alleged neglect or some physical abuse, to have a jury of your peers decide if the facts alleged, number one, are true, and if true, if they constitute abuse.
I want to ask you something. Let's assume that I'm a parent, okay? And I'm going to have my first hearing in a couple of days, a detention hearing. Arraignment detention hearing is the way they used to call them. And I come to you and I say, hey, Jennifer, what do I need to do to get prepared for this quote unquote detention hearing? They've taken the kid away, the kid's in foster care. Let's say I'm a single parent and I was raising this child, and the allegations are, physical abuse, drug abuse, domestic violence, that type of thing. What do you advise me to do and not do to get prepared for the detention hearing?
Well, that's a big question. The first thing that I would advise you to do is to tell me what has happened exactly, and not cut any corners, because I can only represent you, as well as the facts that you give me. The more facts I have, the better attorney I can be for you. Second of all, if there are some things that constitute problems or an environment that maybe needs to be cleaned up a little, do that. Clean it up. If you've got a messy house, clean that up. If you have any or other issues, talk to me and we'll get a service in place to meet that issue, so that when we go into the detention hearing, we can let the court know that whatever issue might have been apparent at the time of removal has been resolved or abated today. And while that may not work at the detention, we would have the right to set a no time waiver jurisdiction contest, and within 2 weeks. At jurisdiction, if a parent has resolved the problems that led to the removal and there are no problems anymore, then the court has no basis to assume dependency or jurisdiction. Now, they do all the time, but in competent hands, that shouldn't happen.
But what if I told you, Attorney Ani, I want you to guarantee that I get this child back at the detention hearing. What do I need to do?
Well, I can't guarantee anything. We're dealing with the system and the courts do err on the side of caution. There's nothing that a parent can absolutely do to get their child back at detention. I mean, it's rare that a child is returned at detention. Yes, it happens, but only in those cases where there's really been a bad removal.
All right. So we have a comment from Roxanne, and she says, what is a detention hearing? Well, Roxanne, in California, they call the very first hearing that you go to an arraignment detention hearing. So you tell the judge whether you admit or deny the allegations they filed against you, and then the judge has a hearing to decide where the child is going to stay pending the next court date. And usually the child is detained in like 99% of the cases, and that means the child's not in your custody. The child's in foster care or with a relative, something like that. But that's why they call it a detention hearing, because the child is detained from you. Now, Roxanne, you may not be in California, and your state might call it something different. I'm thinking some of the names they use, and I can't, my mind is going blank right now, but it's your very first hearing in a juvenile dependency court hearing. So, Jennifer, if go to the detention hearing and the child isn't returned to me, I'm heading towards my next hearing is what? The jurisdictional and dispositional hearing?
Yes. Now, those should be bifurcated in most cases if you're litigating. Jurisdiction, well, there are three main hearings at the start of a dependency case. The detention, which is where the court looks at the case and says, okay, on its face, based upon what I see in front of me, there looks like there's a problem. Jurisdiction is where the court finds, yes, there are problems and defines what those problems are. And disposition is, what are we going to do about those problems? So those are the three stages at the beginning.
And what would you say to me in my same hypothetical fact pattern? What do you think I should be doing to prepare for those hearings, the jurisdictional and dispositional hearing?
Well, services are very important. And services meaning individual therapy, doing 90 days meetings for Alcoholics or Narcotics Anonymous, doing something to show the court that you've taken action to, they say, ameliorate, which means fix the problems that led to this removal. That's very important because the court looks at the parent as being cooperative, as having good prognosis for fixing their problems, and that the home is now safe or safer. So services are very important. It's also important to take your attorney with you to the jurisdictional interview. The social worker will meet with the parent or parents prior to the hearing. They have to write a report that's due 10 days in advance of the hearing, which as a practical matter is never provided that soon. And at the interview, the parent answers questions about the alleged instances. It's very important to have representation at that interview because the attorney can help mold your answers or the actual interview into a helpful event as opposed to a potential harmful event.
What if I want to bring witnesses and show documents at the trial? How do I do that?
Well, you've got to file them and serve them on all parties. And that means that you've got to get them into the court clerk's office. And there are procedures to do that. I think it's probably pretty daunting as a parent to do that on your own. Certainly attorneys can get that done for you. It's very important to get all your information in at jurisdiction because whatever facts the court finds to be true at jurisdiction, that's what you're stuck with. We're not going to be able to change those at a later date, even if the findings aren't accurate. So it's important to get accurate findings at the jurisdiction hearing.
When you do jurisdiction and dispositional hearings, as a matter of course, if they're contested, do you put on witnesses?
Yes. Yes. I mean, at minimum, the social worker to challenge her allegations, but you would put on witnesses that have material points of fact to share with the court. So, I mean, that's a big hypothetical.
So there could be a lot of witnesses.
There could be.
Do you ever find the courts trying to limit the number of witnesses or the length of
All the
time?
time. All the
length
time.
of-
All the
what
time.
what do you think about that?
Well, I take as much time as I need. While the court can say we're going to limit you to an hour, they really can't limit you to an hour. I think that would be certainly writable or appealable immediately. I've never been cut off in my career. I've been limited and exceeded the limitations and received negative comments from the jurisprudence, but I've never been cut off.
I have. And a particular hearing officer limited the number of witnesses and the length of time that I could examine a witness. I appealed it, and in an unpublished decision, the court was affirmed.
It's incredible. It's incredible. What was the reasoning?
It was more of the fact that, number one, judges have the power to control their courtrooms. That was one of the reasons. Number two, I think the court took the position. I can't remember exactly, but it was an immaterial error, if anything, right? And it was one of those things where, I got the impression, well, it must be true, right? And we're not going to waste time or judicial resources in allowing you to call, all the witnesses that you called, and then, take a substantial amount of time. I remember one of the witnesses I called was an expert, and I had to qualify them. And I think, the county objected, but I had to qualify, lay a foundation. And by the time I got through doing that, my time was up. So it was, I don't know, poor planning.
So
At least
on that note, there's a good question in the chat right now regarding presumptive positive tests at a birth of a child. Denise Chavez asks, what if a mother was accused of being on drugs when she was given birth and had test results at the hospital that were presumptive positive, and later on the social worker was found to be fabricating evidence? The important thing about presumptive positive tests, which those are the dipstick tests. So, you give us urine sample and then a dipstick is put in it and it comes up positive or negative. Those are not forensic and are not allowed to be used in court. They're not forensic because of the number of false readings. So a court cannot accept those results, period. They have to be secondarily confirmed, which 98% of the time, a hospital isn't going to have the ability or even the thought to do. So that's an important thing for parents in that situation. And that does happen a lot.
Have you been successful on objecting and keeping that type of evidence?
Yes.
Out?
But I have backed it with a hair follicle sample. So, so that's going to go back 90 days. I always have a parent in that situation. I will always have a parent go get a hair follicle sample. And then with that tends to make the presumptive positive less relevant to the court, even though it's irrelevant as a matter of law. You can't unring a bell.
What have you ever had a client that's told you, no, Jennifer, I'm not going to do a hair follicle?
Sure.
And what's your response?
Okay.
That's it.
Well, I mean, again, you're giving me, I'm going to side with Art on this one. You're giving these big hypotheticals. Obviously, if the test is going to come up positive, I don't want the client to do the test. and I have them do the tests for me. So if they come back positive, we shred them. And if they come back negative, we'll use them.
What about the argument that, hey, just because I tested positive doesn't make it jurisdictional or doesn't satisfy the substantial danger test?
Yeah.
I find myself arguing sometimes, and a lot of times what I feel it's deaf ears. You know, this isn't a strict liability standard,
Right. It sure
right?
seems like it, though.
Right. I
I
mean,
know it's super frustrating, especially with cannabis, which is, arguably, you need to consider it the same as alcohol at this point. Both are legal to consume, and the issue is their conduct incompatible with parenthood? A parent can actually use whatever drug they want as long as there's no conduct incompatible with parenthood. That's supposed to be the law. But in practice, I agree with you. It seems like it's, like you blow up a building with dynamite, it's strict liability. And that's super frustrating. That happens a lot. And part of me wonders whether it's those time constraints that we're talking about, that the courts just sort of, rush through it and say, okay, you tested positive, therefore we're done with your case today.
well, I get that feeling all the time.
Yeah.
And if you tend to argue anything different, it's like, blah, blah, blah. Thank you, Mr. Davis.
Right. Right. So what I've done in a couple of cases recently is set them for no time waiver juris trials. And that has gotten the court's attention in San Bernardino. Monterey Park completely ignores the no time waiver law. Okay, you want a no time waiver? We'll give it to you in 40 days. No problem. That we don't have calendaring that comparts with the law.
There are a couple cases. I don't know if they were published or not published, but out of California, out of Los Angeles County, that go back years, that ordered the court, to enforce that statute. No time waiver, meaning, you start what is it, 15 days, right?
Yes.
15 court days. And I remember there was a case, and I wasn't involved with it, but I heard about it, where I think they got that order from the Court of Appeals or something. And then, there was just one witness called, per day, and it kept trailing. And then at some point, LA County, I don't know if they were made to do this by the Court of Appeals or they just decided to do it. They had something called long cause, whereas one or two judges, and all they did was trials. Like if you had a case that was going to trial and it's going to last more than a few hours or a whole day or 2 days, they'd send you to this long cause. I don't know if they still have that. Do they have that in LA County?
Not where they send you to a different court. Trials are looked at as short cause and long cause somewhat. I know that in Santa Clara, they do have a different court that you'd be sent to. I find, though, that what is troubling, when you come back for these check-in or readiness hearings, you can get another readiness hearing and another readiness hearing and another readiness hearing. And, getting actually to the meat and potatoes of the case, it takes a lot of effort sometimes. And I'm not sure, it just seems like there's no sense of urgency in the courts.
When things happen to my clients like that, I try to get them to participate in services, because a lot of times I argue, even if you find something is true, Judge, the risk has been ameliorated or taken care of or fixed. And there's really no need for jurisdiction or no need to place these children in foster care.
Right.
So the example that I used to do this all the time. The dirty drug test at birth, and then I'd get my client into testing right away. So by the time we got around to the jurisdictional or dispositional hearing, my client may have 10 weeks of clean tests. And irrespective of what happened at birth, allegedly what happened at birth, it would seem that with 10 weeks that you have proved otherwise, especially that, you're not a person who has a drug problem that can't take care of a child.
Right.
If you're an addict, you're testing dirty every day or every week, and there's nothing that you can do about it. And I tell the judge, well, test and clean 10 weeks, 12 weeks, give the child back and make a condition that you still have to drug test, right?
Right. No,
Those,
absolutely. Absolutely. And, continuing a jurisdiction hearing is also a useful strategy. I had a case where a mother was facing a B11 bypass for violent felony conviction when she was 22. She's now 36 and had an infant. Domestic violence in the home, had the infant removed as well as her 17-year-old removed. And I continued the jurisdiction hearing and got her into all types of services with providers who I knew would come to bat for her and testify. And by the time juris rolled around, I was able to get county council to agree to offer services. And she's now reunified with her kids fully.
that's great. That's a brilliant strategy. Tell me, you used a phrase there, and the phrase was you put her in services with providers that would come to bat for her.
Mm-hmm.
Why did you say that?
Well, because I wanted providers who are comfortable testifying.
Do you ever?
And I knew that they would testify positively because in meeting with the mom a few times, I could tell her character and that she wasn't someone who should be subject to the bypass. She's a good mom, and luckily things worked out. But service providers who will testify makes the department it just checks them a little bit because they have to be on their best game as well. They don't want to go to trial and lose, right? The department doesn't want to do that. So if you get providers who are willing to go to bat or come into court and testify about the positive progress the parent has made, or in my case, I just provided letters at the outset.
No, that's interesting. Did you have a problem getting those letters into evidence? Because they're hearsay.
Well, they didn't come into evidence because remember, we settled. So it was I front loaded the case. First I continued it and I had the mom do every service under the sun with, again, providers. And then I had the providers write very specific letters for her addressing each element that was a problem or a concern in the report. And at that point, the department, I'm not going to say they said uncle, but they said uncle. They didn't want to go forward with it.
I hope the people that are watching this listen to what you just said, because that is a brilliant legal strategy. Tell me what you meant by I front loaded the case, because everybody watching this or whoever has a CPS issue, you can learn from this strategy. Tell us exactly what that means.
Front loaded, meaning that I am providing all of my evidence, which was in this case, letters from therapists, letters from her landlord. There was a domestic violence issue. I had her get a lease that was in her name only, that hence the landlord. Letter from the person that she was working for, letter from the caregiver who was her sister. Front loading it, just giving all that to the county council in front, say, this is what I'm going to bring at the trial. This is what you're going to be up against. Are you really going to tell me that this person is not capable of parenting their children? Of course not.
So, sometimes I get a case where the person is so adamant that they didn't do it. And when I suggest front loading and getting into some classes or counseling, they go ballistic on me. But
well, it's sort of like, this is a foolproof way to get your child back. As foolproof as it can be, is to just address every concern in the report. So there's nothing more to be concerned about. Even if a parent isn't guilty, we can all use individual therapy, right? So just have them go see a therapist.
A lot of people think that if I go see a therapist or go to parenting classes, that I'm admitting my guilt. Is that the way it works?
No, of course not. Therapy is meant so that a person can address any stressors in their lives. The understanding is that those stressors may manifest in some type of conduct incompatible with parenthood. Everything in therapy is private, won't be revealed to the courts. So you can tell your therapist whatever you want to tell your therapist, and they can't reveal that in court unless you give them express permission. It's not admitting anything, it's playing the game to a degree. But do you want to get your child back, or do you want to be right? I caution my parents against being right fighters, because you can be a right fighter all you want and still lose the big picture.
I tell people that all the time. I ask them, do you want to be right or do you want to win? And they kind of look at me like, well, it's the same thing, isn't it?
No. And a comment in the chat says, it can be a problem when they control the therapist, it meaning a parent seeing a therapist. Yeah, absolutely. I have parents go to a service provider of my selection. A minute ago, I was talking about front loading. I would never use a CPS connected therapist for that purpose.
Is that your general rule, that you send them to people that you know are qualified?
Yes, I do. And I try and match clients with service providers that I think are going to be a good fit, so that it's not, just talking to an empty space, somebody who they can connect with. At this point, I certainly know my share of therapists in the area. So it's important to get a therapist who the client can feel safe with, and ideally who will testify that their parent does not present any safety risks.
I did a case in a county, I guess earlier this year, and there was a problem because the parents went to a counselor that wasn't on the CPS approved list. And part of the disposition court orders in writing were you had to go to a therapist that was on the CPS approved list. What do you think about that?
Well, so when they say it has to be an approved therapist, really what I choose to interpret that to mean is that it needs to be a qualified therapist. So I've never had a problem where they have rejected the therapist that I've selected. Yes, I've had that same order, but they don't have to. All that really means is that CPS is paying that person's tab, and as long as the therapist that you select submits a report, as the other therapist would do, that includes the frequency of therapy and the goals. And then generally, if the client is working toward those goals, meeting, surpassing those goals, et cetera, and that's all that's required. I don't think that the court can legally require you to see somebody who is a department provider, because that seems more fiscal to me.
Right. And a lot of times when a parent does go to a department provider that is paid by the department, I get the feeling a lot of times that they don't want to lose that paycheck and therefore feel a little pressured with, going along with the department party line. You ever find that to be the case or get that feeling?
Just once or twice. Yeah. No, yeah. No, I mean, that's a big problem, and what the issue there is who is, is this the expert for the department? So if there's a communication between the service provider, the therapist, and the department, that's an improper communication. It's the court's expert. When the department sends a client to a approved or on the list therapist, that therapist is the court's expert. And I can ask any questions that person that I want to, but 100 out of 100 times they say, no, we're not going to talk to you.
How long have you been an attorney, Jennifer?
Since 1993.
Okay. So a long time.
Yeah.
So
I don't feel like that old, but it's been quite a while.
But my point is, you have a lot of experience. You've done many, many, many cases. What do you think the one thing you would recommend if someone, legislators came to you and said, what do you recommend to make this a better system? What would you recommend?
That's easy. Allow direct lawsuits against social workers. Remove
Really?
their qualified immunity. Yeah. If we were able to sue them for wrongful removals outside of the warrant issue, and they had to pay out of their pocket, that would change things really fast.
Well, That's interesting that you say that, because right now, if I sue a social worker and they lose or they settle, the county is the one that pays the tab, right, for the social worker. So it's almost like, well, you can't go after the worker because we're going to pay the money. So you can't do anything. So I don't know if
Right.
that would really change, because your employer, is still responsible for you.
Well, but
To cer-
I would assume though that the county would be displeased with an employee that was, requiring them to pay bills for. I don't know. Well, then make it both ways. Make it. I mean, why can't you sue the county and the person in their individual capacity?
right. That
I mean,
that's an interesting point. You know, you said something that's very interesting. You would assume that the county would have a problem with it, but remember, the county is spending your money, not theirs.
yeah, it makes me sad as a taxpayer. That's for sure. Going into these cases, there's so much waste. So much waste.
Every year it seems like, at least they've done it several years. The Times at the end of the year or the beginning of the year writes an article, Los Angeles Times, about all of the money, the millions and millions of dollars that are paid out for social worker cases and sheriff cases. And the reason why they write this article is because they keep asking, when is the county going to do something
Mm.
to fix these problems? Obviously, there's an issue, there's a problem, there's a way of the county, certain people do things, and, there's nobody there to check it or correct it. And what the Times wants to know is, well, why isn't the county government requiring sheriffs to change or social workers to change? And one of the reasons is because, these organizations are old and entrenched. And it's not easy to go down into the any field office and tell a social worker, well, you have to change the way you've been doing things the past 20 years. We want you to be, quote unquote, a little bit more responsible with people's rights.
Use a
One,
Obtain a warrant before removing.
right. There was a guy down in San Diego who brought a lawsuit about that issue, and
Mm.
I think the county promised, in the future they would do that, but they still occasionally go ahead and, detain a child without a warrant, and then try to rely on some type of emergency situation in the future. But here's one of the things that somebody, that watches this show said last week. They would require social workers to wear body cams.
Absolutely.
What do you think of
That would
that?
be amazing. That would be amazing. That would be amazing.
So, everything's videotaped and audio taped.
And we should allow, I mean, now the issue of a parent taping that sort of a situation when it's going down, right? That's a hot area. I think parents should be able to do that. And I tell my clients to put a sign in their window that says this premises is under surveillance. Then they know when they go in that they'll be under surveillance.
There was some legislation in California that allowed people to tape with their tape any videotape or audio tape any interaction with a social worker without warning the social worker that he or she was being taped. And that bill went
Yeah.
down
Yeah, I'm
into
familiar with
the
that. I think Tim Donnelly was involved in that. That I don't know why though. Why wouldn't they want to be taped? What's the problem? Really, right?
money, money, money. Because if they're really doing crazy things as these parents allege, it's going to be all on tape.
There's
And
no
it's going to be
doubt
hard.
they're doing crazy things. There's no doubt in my mind. I mean, and as you know, Vince, we hear some crazy stories, but there's no doubt, there's no question that I'd say 90% of the parents are telling me 100% truth. I mean, social workers act with impunity. They really don't have limits, and very few are ever corrected by their supervisor or otherwise. I mean, they don't have any consequences.
Right. They don't have any consequences, and that's the problem. Because even if they are sued and they lose, the county pays the bill. So it really
Right.
didn't matter, you know. And, you know, there was a famous case in Orange County, and one of the guys that's a guru in this area, Sean McMillan, in civil rights cases, and he's from San Diego if you guys are trying to contact him. But he won a case. It went up on appeal, and I forget on appeal if he won or lost. I think he won, and then it went to the Supreme Court, and they, decided not to hear the case. And it was a multi-million-dollar verdict. And apparently someone in the county was later interviewed. I won't say who, but allegedly this person was interviewed and said, the courts got it all wrong. The jury, the appellate courts, everybody got it all wrong. And if we had to do it again, we'd do the same thing, or words to that effect. Now, here they just lost a multi-million-dollar verdict. The jury said they were wrong. Trial judge said they were wrong. Appellate court said they were wrong. Supreme Court refused to hear it. And what? You didn't learn anything from that? You know why? Because it's not your, multi-million-dollar verdict. You're not going to pay it. The people of that county are going to pay it. And if you think that you're doing the right thing, and you're saving lives and you're protecting children, everything's under the rubric of we're going to protect children no matter what. We're going to ruin their lives, their families' lives, but we're going to protect them. We're going to protect them. Right.
Right. No, it's really, the pendulum has swung so far on the side of, removing on the side of caution. There really needs to be more emphasis on the family's right to be together and not, they really need a really good reason to remove. I definitely think that the positive drug tests at birth, I think that's a huge area, a huge problem area. Just huge. In fact, the law says that you can't remove for a positive drug test alone. And so then they combine it with, look, she's doing something crazy, right? They just make up things. It's why I still stay in this area of law, Vince. There's so much work to do.
Do you think that it'll ever change during your career or lifetime?
It being the irreverent actions of the department? No, I don't.
I don't know if I've ever told you this. We work together, but I don't think you know this. We're launching an organization, and we're forming the organization now as a 501c4 with a sister 501c3, kind of like an advocacy group to lobby and to support candidates, because the only way this is going to change is by people vote, change laws, put in legislators, judges that are family friendly. And that's the only thing people have is the vote. And if you carry a block of votes, 500,000, a million, whatever the number is, people are going to have to deal with you and deal with the way the laws are written and are enforced now. Because the lucky thing here in California, state legislators and senators are all voted in and out of office.
Right.
But the same is true with judges and appellate court judges, right?
Right.
Even if they're appointed, they have to get reelected.
I think one of the problems that I see is that until they're involved in the system, most people think that CPS is necessary. Most people think that parents have done these horrible things they're being accused of. There's just this blind, trusting of this agency that really shouldn't be trusted.
A few years ago, I ended up taking the deposition of a social worker, and it was videotaped. And in this deposition, the social worker admitted to not telling the truth under penalty of perjury. Admit it. Now, before that happened, I think the offer for settlement was like $10,000, right? Well, the offer for settlement skyrocketed and I spent about 40 minutes questioning her at every angle to make sure she couldn't slip out later. And at the end of the deposition, everyone left, and the attorney for the social worker, who's a very prominent attorney, said he wanted to talk to me. So I stayed and we chatted. And the first thing he says to me is, you know what, Vince, you had more fun than any attorney is or should have on any case today. And he says, let's go to dinner and let's talk about settling the case, right? Because he's a smart guy. He realized what that was going to look like. And no matter what I did at that deposition, I later made a motion to strike the answer of this particular social worker for lying under oath. That motion was pending, but they did file an opposition. And they came up with what was a brilliant reason about why she didn't admit to lying under oath. I mean, it was brilliant. But, it was like, okay, is the judge really going to buy this? But before that motion could be heard, the case settled, of course, because although brilliant, it was kind of like, come on, be for real. The Ninth Circuit videotapes all its oral arguments. Yep. And I saw there's one oral argument that's floating around the internet, but you can just go on the Ninth Circuit's website. And it's where the county lost at the trial court level in federal court because the social worker had lied under oath. And the defense attorney sent this it seemed like she was young, attorney to argue that a lying social worker should have immunity, for everything else. And the judges, who are all conservative judges, I think they were more outraged than the other side.
Didn't they say, what part of tell the truth don't you understand? I mean, they said something that flippant. I can't remember what it was, but it was something like that.
Right. But this just goes to show you how far the county will try to press something to give them the ultimate advantage. Our workers can go to court and lie, and they shouldn't be held accountable.
I don't know how to change that except for allowing direct lawsuits against them. If they have to pay, if they personally have to pay, maybe they'd stop lying.
I think you might be right. But the only way to make that happen is through legislation.
Right.
You have the right to a jury trial. You have the right to tape the worker, and you have the right to sue her individually, where the county...
That would help.
Right. And if the jury found her liable for example, lying or violating the rights, the county is forbidden on paying the judgment if she has assets. And then anything left over, you can go after the county for.
Right. She has to pay out of her assets to the extent that she can, and then the county pays the rest.
Right.
Right.
You might be onto something there. I never really thought about that.
Let's do it.
I think you're onto something. Well, we're coming to the end of our time, an hour. Time goes by fast when you're having fun. I want to thank Jennifer Ani for joining me. If you want to get in touch with Jennifer, you just call my office. We work together at 888-888-6582. Jennifer, thank you. I appreciate you coming on tonight, taking the time to spend with us tonight on Meet the CPS Experts. And for everyone, I want to thank you for watching and listening. And don't forget, tomorrow night at 7, we have our live stream. And tomorrow night is the new social media influencer, Erin Carranza, and her show, CPS Family Reunification, Coaching and Motivation. What do you think about that show, Jennifer?
I think I'll watch that.
Helping people with their reunification services and how to do visits and how to stay motivated. One of the things I found is people sometimes don't do FR services because they're depressed. They lack the motivation. Mm-hmm. They're like a totally defeatist attitude. And it has nothing really to do with, keeping the kids safe. It has more to do with, what kind of person are you?
Everything is
anyway.
case by case, for sure.
Yeah, that's a whole nother topic.
Yes.
Thank you,
Thank you,
everyone,
Vincent.
and
Thank
good
you.
night.